Good morning and welcome to the Equal Opportunities Committee's 21st meeting of 2013 and our first meeting after the summer recess at this wonderfully bright and fresh hour. As Deputy Convener, I'm chairing this meeting until the committee chooses a new convener, and I'd like to take this opportunity to record our appreciation of the work of the outgoing convener, Mary Fee, and I also welcome the committee's newest member, Margaret McCulloch. Can I remind everyone, as always, to switch any electronic devices to flight safe mode or off entirely. No apologies have been received. So in accordance with Section 3 of the Code of Conduct, I invite the new member to declare any interests relevant to the committee's remit. Any declaration should be brief but sufficiently detailed to make clear the nature of the interest. And of course this is for Margaret McCulloch.
Okay. Can I refer to my declaration on the parliamentary website?
Thank you. Okay. The second item on the agenda is to choose a convener. The Parliament has agreed that only Scottish Labour Party members are eligible for nomination as convener of the Equal Opportunities Committee, and I therefore invite eligible nominations. Well, I have received one nomination, unless Alex Johnson was going to stage a rebellion there.
I wasn't going to come in with an alternative. I was going to say that having worked with Margaret McCulloch in a number of capacities over the past 2 years, I think she would make an excellent convener for this committee.
Well, one nomination has been received, and I therefore ask that the committee agree that Margaret McCulloch be chosen as convener of the committee. Are we all agreed? Yes. We are agreed. In that case, I congratulate Margaret McCulloch, and I suspend briefly so that we can swap seats.
Yeah. First of all, can I thank you all for choosing me as your convener? And moving on to agenda item 3, this is a decision on taking business in private. You're actually asked whether you want to take agendas items 5 and 7 about our approach to scrutiny in private in line with usual practice. Are we all agreed?
Agreed.
Agreed. Okay, that's us agreed. Agenda item 4 is on witness expenses. In line with usual practice, members are invited to delegate to me as convener responsibility for arranging for the SPCB to pay under Rule 12.43 any expenses of witnesses in our scrutiny of the Marriage and Civil Partnership Scotland Bill. Are we all agreed? Agreed, okay. Can we now suspend briefly to move into private session? Ready? Yeah. You okay? Yeah. Can I resume the meeting now? And I'd like to welcome the witnesses and welcome those sitting in the public gallery. Today we have two panel of witnesses giving evidence on the Marriage and Civil Partnership Scotland Bill at stage 1. And can I also let the witnesses know and the public gallery that the parliamentary photographer will be here as well. And can I ask the first panel of witnesses to introduce themselves, please? And we'll start with Mr. Macfarlane.
Thank you very much for having us here today. I'm Colin Macfarlane and I'm the Director of Stonewall Scotland.
Thank you for inviting LGBT Youth Scotland. My name is Brandy Lee Loftinell and I'm Policy and Participation Manager.
Good morning. My name is John Phillips and I'm representing the Quakers in Scotland.
Thanks very much for the opportunity to be here. I'm Tim Hopkins, the Director of the Equality Network.
Thank you very much for inviting the Scottish Transgender Alliance. My name is James Morton. I'm the manager of the Scottish Transgender Alliance.
Yeah. I'm now going to hand over to our committee members, and the first person we have to ask questions is John Mason.
Thanks very much. Thanks for all your submissions, which I've read, which have been very helpful. And I don't know if you've possibly seen submissions from other panel people as well later on. One of which talks about the complementarity of male and female. It said the complementarity of male and female and their unique role in the transmission of life underscores the reality of marriage as a natural social environment for the birth and growth of every person. Can I ask, do you agree that there's a complementarity of male and female?
I'll go first. Gender is not that simple. We know, for example, that there are transgender people. There are people who are born into a male body but grow up to discover they're female. There are people who are intersex who don't have a male or a female body but a mixture of those two things. There are people whose self-perceived gender identity is neither male nor female or a mixture of those two things. So reality is simply that things aren't as simple as people being male or female. In terms of, you mentioned generation of new life. In terms of that, it's already clear that marriage law does not require the couple who are marrying to be capable of having children. There are couples where one person is infertile. There are couples who are quite old and are not going to have children. There's no...
The norm would be that a marriage would expect to have children.
Most marriages do have children, and of course many same-sex couples have children as well, and the kind of couples I've just talked about where they're not able to have their own children may well adopt children, for example, as same-sex couples do as well. I mean, our point of view is that this bill is about love, and marriage actually is about love. I think if you speak to most married couples and ask them what their marriage is about, they'll say it's about love, it's about a commitment to each other, and it's about, if they have children, it's about their family. All of those things apply to same-sex couples as well.
I come from a slightly different point of view, from one of the faith communities in Scotland, and for us the crucial thing is the complementarity between two individuals who are making a committed relationship with each other and need the support of their community and of God helping them through their lives in this way. The complementarity is not to do with gender. It's to do with this particular relationship which they work out between themselves for the benefit not only of themselves but of the community in general.
Certainly, sorry. I mean, we're of the view and we're alive to the fact that there are now, an increasing number of gay and lesbian people, particularly younger ones, who want their family structures to be described in exactly the same way as everybody else's. And Tim's alluded to same-sex couples who have children. But for us as well, the marriage bill as itself is much more than just about the complementarity issue. It's much more about how gay people are viewed in society and how they're seen in society, and about being equal in the eyes of the law. And what this bill does for us is completely underline that it's a robust, strong bill, and what it will do is provide to provide gay people with that legislative equality in the eyes of the law. When civil partnerships were introduced, in 2005, we were very much of the view, and we hoped that those distinctions between gay people and straight people and heterosexual people would be eroded. The way that gay people were talked about in the public sphere and how they were viewed in the public sphere would change. But our hard evidence has shown, sadly, that since 2005, when civil partnerships were introduced, that's not been the case. Research that we commissioned from YouGov, that Stonewall Scotland commissioned from YouGov, showed that 216,000 people in the last 5 years have seen some form of homophobic or transphobic, verbal or physical abuse in the workplace. 99% of our young people have faced some form of discrimination or seen some form of homophobic language in their playgrounds. Half of those children have been directly bullied themselves for being different or perceived to be gay. And we've seen in the last year a 12% increase in LGBT-reported hate crimes. So what this bill for us does is make gay people equal in the eyes of the law. And until that happens, that distinction and that public discourse, we feel, will be at risk of not changing.
I mean, can I follow up on that then, that, equal in the eyes of the law? I mean, are you accepting that the law already gives equal rights? So really this debate is about the word marriage rather than legal rights, or are there legal differences as well?
Well, it's about, at the moment, gay people are not equal in the eyes of the law. They're not equal in law. So until they're afforded the same rights and responsibilities as heterosexual married couples, until they are able to marry legally in this country, they will not be equal. And that distinction then continues. And as I mentioned, that distinction then allows in the public sphere that kind of discrimination that I've outlined just a few minutes ago. So we're very much of the view that until gay people are seen as equal in the eyes of the law, and society sees them as equal in the eyes of the law, that distinction will continue.
I mean, the Equality Network, in your paper, you talked about the legal rights and responsibilities of civil partnership and marriage are almost identical. I mean, are they exactly identical, or can you clarify for us, would there be some changes?
There are two significant differences at the moment. One is in pension rights for survivors' pension, and the other is in international recognition. The international recognition regime for civil partnerships is much weaker and not common across countries that have civil partnerships, whereas it is for same-sex marriage. There is another very important area of legal discrimination, and that's for transgender people. Because we have this segregated system of marriage and civil partnership, if somebody changes their legal sex because they're transsexual, then they have to end their marriage and then start a civil partnership, and that causes all sorts of difficulties for people. So that is a very important piece of legal discrimination. I think for us, though, it's actually more about practical discrimination, and it's about status and stigma. Marriage is perceived as the gold standard by many people for relationships. Even civil partners, when they propose to each other, don't say, "Will you civil partner me?" They say, "Will you marry me?" And people have been quite distressed by the fact that, for example, they go to the bank and the bank doesn't understand what civil partnership is, or the bank has a form to fill in and it has boxes for marriage, but it doesn't have boxes for civil partnership. This kind of thing is still quite common. So practical discrimination against civil partners. We did a survey and 103 people in civil partnerships answered it in Scotland, and I think it was 58% of them reported that they hadn't received the same respect or the same treatment as married couples would have for these reasons. For example, people have said to us, "But it's not a real marriage, is it?" We've heard of hospitals where people have been turned away as next of kin because the hospital has not understood what civil partnership is. One of the effects of introducing same-sex marriage will be to make that less likely to happen.
Do you think that'll change the legal status? Do you think it'll change people's attitudes, or will people just talk about real marriage and gay marriage and have different terms?
I don't think so. I think that marriage is understood widely, and I think allowing same-sex couples to enter marriage will not only help them feel better about themselves, but that I think it will genuinely reduce stigma that people feel and discrimination that people face in society.
Can I bring in James just now, please?
I would also like to add that John Mason mentioned sort of male and female, and intersex people where their bodies are at variance with what's clearly male or female have contacted us and said that they're under massive amounts of stress, and their partners as well, about the worry that while there isn't same-sex marriage, that their relationships might be challenged. So somebody might say, well, your body isn't clearly male, therefore your marriage, even where you're the husband and your wife, isn't legal because you really shouldn't be counted as male. And that causes massive amounts of distress So in addition to the detriment and discrimination faced by transgender people and their spouses by the current separate systems, there's also this intense worry and distress for intersex people and their partners.
You finished, John? Yeah.
On that area, yes. Sir.
Yeah. Siobhan, would you like to ask questions?
Yeah, thank you. A number of organisations have stated in their written submissions, and Mr Macfarlane, you said that again in your answer to John Mason, that you believe there's robust protections in the bill. I was just wondering, what are those robust protections, if we can have some examples of what you believe are robust?
I think we've had a really lengthy consultation over the last 2 years, and I think the Scottish Government has listened to the concerns of those that had concerns about the protections. I think the protections within this bill are robust and are strong. They've got the balance right between the freedom of speech and the freedom of religion. I think the modifications and the amendments that the Scottish Government have asked the UK Government to make in terms of around celebrants, etc., are strong. And I think, this bill is robust, it is strong, and I think the Scottish Government has listened to those concerns and should be applauded on that.
In particular, what's robust? Sorry, I mean, because we're talking in general terms about the bill, but specifically the amendment, for instance, we know that the consultation that was taking part with the Scottish Government and then again the Equality Impact Assessment came out and the responses to that suggested that, yes, it's all very well in practice, the Scottish Government saying they would like to do something, and people accept that and, wish for that to happen. But in practice, that might not be the case. So what gives, the feeling that actually this will be the case? Is there something specifically?
I think you, and I understand where you're coming from, I don't think you're ever going to prevent people making mischief. I don't think you're ever going to have a cast iron guarantee that somebody isn't going to maybe at some point try and take somebody to court. But I think the protections, as I said, are robust. The Equality Act amendments are robust. If you look across Europe, where there's been 9 countries, I think they're under the jurisdiction of the ECHR, so the European Court of Human Rights. They've had equal marriage for around about 12 years now. Not one single religious group in those countries has been forced to carry out same-sex marriage. I think the protections are strong in our law. I think they're strong in terms of international or European law. And I think those laws and those protections are robust.
Just add to that, I agree with Colin that the Scottish Government has done a very good job of drafting the Equality Act amendment and getting that agreed by the UK Government. It's much stronger than the draft that they published last December. They've really listened to the concerns of churches about, for example, making sure that people who take part in religious services like organists and people in the choir and so on can opt out of same-sex marriages, and they're free to do that. They've listened also to concerns about people who control religious premises being able to veto any other group who rents those premises conducting a same-sex marriage. So those protections are all there. The concern that's been raised has been about the European Court of Human Rights and the European Convention on Human Rights. But actually, if you look at what has been said in legal opinion by lawyers who are experts on human rights, they're very clear that Article 9 of the European Convention, which protects the freedom of religion and the freedom to manifest your religion, actually protects churches from having to conduct same-sex marriages. If the Scottish Government had, which they clearly wouldn't, but if the Scottish Government had written into this bill that churches had to conduct same-sex marriages, those churches would be able to win cases at the European Court of Human Rights because Article 9 protects them. So not only do we have the domestic protection in the Equality Act amendment, but we also have that underpinned by the European Convention itself. So I think there's absolutely no prospect of anybody successfully taking a church to court and saying you must do my same-sex marriage. The bill improves religious freedom by giving religious groups the freedom to choose, and we've always said that should be the case, and we're very glad that the bill does that.
I appreciate your answers up until now. It's just, do you appreciate that it's not just about the ceremony, it's about wider implications in that? So, for instance, those in public bodies, their employment, again, do you feel the protections are robust for them as well?
Yeah, I mean, there's been a case down south, Adrian Smith versus Trafford Housing Trust. Mr. Smith was posted on his personal Facebook page that he disagreed with same-sex marriage, and Trafford Housing Trust then demoted him because of that. Now, that shouldn't have happened. He went to court and he won his case. The court was very clear that that amounted to unlawful dismissal. So the law already is clear that you cannot be subject to a detriment by your employer because you have views against same-sex marriage. So we do think that the protections are already there.
Okay. Would anybody else like to comment? Randy, Mr. Phillips, or James?
I think that's sufficient.
Okay.
Before we move on, could I come in on this?
Yeah, certainly.
I just following on from this, I have a question for Mr. Phillips. We've talked here a lot about religious protections and religious freedom. Do you believe that the current situation where, as a faith, you are forbidden from performing same-sex marriages is itself an infringement of your religious freedom?
We do. We have, of course, a number of gay couples in our Quaker meetings who have civil partnerships. And talking with them and working with them, we can see that they feel that they have not been given the same opportunity, either by the Society of Friends or by society at large, to really sanctify their relationship within the context of the religious community within which they practice. This has become clear to me really only over the last 5 years or so, since we've had a number of civil partnerships there. We can, of course, hold meetings for worship for blessing these couples, but there is something rather special about making the declaration itself within the context of the religious worship. And it's that which they feel singles them out as being different from opposite-sex couples, and which we have learnt to greatly regret.
Moving on, John Finney, would you like to ask your question now as well, please?
Okay, thank you, Convener. Morning, panel, and thank you all for your submissions, which have been very interesting. I would like to address a series of questions, if I may, Convener, to James Morton there, regarding your submission, and helpfully the suggested amendments you've put in. If I refer to the first one, which is perhaps less technical than some of the others, about the gender neutrality of the ceremony, could you comment on that, then perhaps cover some aspects which many people would perhaps have some difficulty grasping? I did it initially myself.
Many people don't realise that somebody's legal gender recognition in one country doesn't automatically get recognised in other countries. So you can have a situation where a trans woman has gone through gender reassignment from male to female, fully been legally recognised in her home country, for example, sort of in America. But then if she comes to Scotland, that is not automatically recognised. She would still be legally male in the UK law's eyes. And therefore, if she saw herself as lesbian, had a female partner, and was wanting to marry in Scotland, under the current sort of like kind of proposals of the bill, she would be required to declare in front of all the wedding guests that she was the husband. Now, obviously, this is going to be a gross violation of her dignity, her privacy, causes such humiliation and embarrassment on what should be a really happy and special day. And all that would be required to enable her to not have those violations of her dignity and privacy would be to allow the option that where the couple and the religious body that are marrying them both agree that they could use gender-neutral language, such as saying, we pronounce you married, we are now married, rather than saying you're now husband and wife. We completely respect that some religions might want to stay with always using gendered terms of husband and wife, and that's absolutely fine. We just want those religions, such as the Quakers, the humanists, the Quakers, the Unitarians, and also the humanists, to have that option of respecting the privacy and dignity and allowing gender-neutral language where somebody is technically in a mixed-sex marriage, entering mixed-sex marriage, but actually doesn't perceive themselves as the gender that's on the legal status.
Thank you. The so-called spousal veto, can you perhaps expand on that and its relationship to the legislation in front of us, please, Mr. Morton?
Okay. Basically, the spousal veto amendment is needed to remove the ability of one spouse to obstruct for years their partner's gender recognition. Now, the European Court of Human Rights has recognised that having your gender identity legally recognised and respected by your government is a human right. It's a very personal issue. It's not something that another person should be able to block. So what we want is to make sure that the balance is the correct balance. At the moment, we feel it's disproportionate to allow a spouse to block the whole gender recognition of their partner. But we do recognise that some spouses might feel very strongly that they want the marriage to continue being seen and have the marriage certificate only in the original way, as it was originally solemnised. So we're proposing that the amendment allow the transgender spouse to receive their gender recognition while still remaining married, but without their partner's consent, the marriage wouldn't be re-registered to show the new details. Now, a marriage between a trans person and a non-trans person, which happens before someone's gender recognition, is regarded by the bill as a protected marriage. There is no change to the pension rights, to the parental rights, to any aspects of the marriage by the granting of the gender recognition of one party. It is recognised that when it was entered into, it was a mixed-sex marriage, and we feel that the amendment enables that balance between the rights to gender recognition for the trans person, which is their individual human right, and the right of the non-trans spouse to avoid getting given a marriage certificate that reflects new details. Indeed, we actually feel that the amendment we're proposing provides better protection for those spouses who do not wish to divorce their transgender partner, perhaps for religious reasons. They might be against divorce, but also don't want to have any change noted on their marriage certificate, because they feel strongly that how it was originally solemnised is what counts.
Can I come in on that? Yes. We're going to move on. My understanding with the operation of this is that the veto applies to the application for gender recognition, but in order to apply for gender recognition, you would have to have been living as the other gender for 2 years already, during which time you would expect, presumably if there was an objection, other measures such as divorce to have been carried through. Is that correct?
Yes. In effect, the gender recognition part has less impact on the non-trans spouse than the 2 years or more decision by the trans spouse to start living publicly, to come out and start living publicly in the new gender. And at that point, they change their driver's license, their bank cards, their passport, their employment records, their NHS records. Everything at that point, 2 or more years before the gender recognition, is all changed, and publicly they are living in that new gender. So if their partner is profoundly uncomfortable with that and doesn't wish to remain married to a transgender person who's transitioned, then they would have had over 2 years to have started divorce proceedings if they wished, on the grounds of unreasonable behaviour. So it doesn't remove, our amendment doesn't remove any rights for people to divorce their transgender partner, and indeed the gender recognition has less impact than the original medical treatment and social gender change that's already occurred.
Yeah, that transition sounds like it could be quite an arduous process for people, both bureaucratically and potentially emotionally.
Yes, we recognise that it can be profoundly difficult for a spouse to come to terms with their partner's transition. And that's another one of the reasons why we think that the access to gender recognition should be separated from the issue of whether they continue or not that marriage. Sometimes it can take a number of years for people to feel more at ease with that experience, and they may want to kind of wait and see how they feel, rather than have to make a fast decision in order to allow their partner gender recognition.
Yeah, yes, thank you, Convener. Can I ask about, there's a suggestion in your evidence about the reinstatement of rules securing gender recognition. Could you expand on that and why that's important in relation to the legislation, please?
Yeah, back when the Gender Recognition Act was first introduced in 2004, there was a 2-year period where they allowed people who had been transitioned for more than 6 years to get their gender recognition without having to provide the same level of medical evidence. The standard route requires that you provide not only a letter from your GP detailing what medical treatment for gender reassignment you've had, but also a letter evidencing exactly how you were diagnosed by a gender specialist. Now, you can only access that letter from the gender specialist while you're still in touch with the gender specialist. And if you've been transitioned for over 6 years, you'll be out of that system. You'll no longer be attending a gender identity clinic. And therefore, you would have to try and re-enter that system, which currently takes between 1 and 2 years to get a first appointment. You'd be taking up a space that could otherwise go to somebody more in need, just to get sort of like kind of re-diagnosed for the purposes of proof for the gender recognition panel. So what we're proposing is that the long-term transition route be reopened in recognition of the fact that there were people who couldn't access it the first time round because they didn't want to divorce, or because they disagreed with the discriminatory requirement to divorce for other people, so felt on principle that they shouldn't be taking advantage of a system that their fellow trans people couldn't access. So we feel that it would be of benefit to transgender people and also to the gender recognition panel, because where there's this difficulty gathering evidence, it causes much more time-consuming process of trying to help that individual get through the gender recognition process by the panel. We feel it would be to the benefit of all to reinstate that option and enable people to just show that they've been over 6 years transitioned and provide a GP letter evidencing their medical treatment and get it on those grounds.
Yeah, I've one final question for me, Convener.
Sorry, before you move on. Just to clarify for that, are you referring to this being put in place for people who were eligible originally because of the time, the period in which they transitioned, rather than all people? It's simply reopening that route retrospectively?
We think that it's best to simply reopen the route and not try to define exactly who would be eligible for it. The UK government tried to do a sort of restricted opening, but they seem to have actually not quite got that grouping right. It's very hard to kind of select exactly the right people. We think that there's other reasons that people may also need to use that long-term transition route, particularly if they live in, say, a rural Highland area. They may yet not have even heard of the Gender Recognition Act. It can take a long time for people who have been long-term transitioned and therefore no longer in connection with any transgender groups or just living their lives to find out about their rights and be able to access things. So we feel it would be fairest just to simply reopen it as a route for anybody who's over 6 years transitioned.
Statistics available for how many used that route when it was open for 2 years? Is that something you could provide perhaps in writing later if you don't have it to hand?
I would need to ask the Gender Recognition Panel to provide those, but yes, we can collect those and pass them on.
Okay, thank you.
John?
Yep, thank you, Convener. The final question, Mr Morrison, relates to the current requirement that someone needs to be at least 18 years of age to secure a gender recognition, and the suggestion from yourself of lowering it to 16. That may be seen as controversial by some people. Would you like to explain why you think that's appropriate?
Yep. At the moment, the way the bill is currently written, there will remain discrimination against transgender people who are aged 16 or 17. They will not be able to access a marriage or a civil partnership as they identify, because they are unable to legally change their gender. Now, making the age at which someone can get gender recognition certificate equal to the age at which they can undertake the life-changing decision of marriage and founding a family would not encourage in any way people to transition younger or for more people to transition, because it is not about the start point of a transition, it is about recognising the end point. It's not about access to medical treatment, it's about recognising that there are a small but significant number of transgender people whose identity as the other gender is so profound and so known to them from a young age that with parental support they have been living in the other gender during their teenage years. It's only with parental support that they would have been able to change their school records, change their NHS records, change their name, and therefore be able to evidence that they are ready for the gender recognition certificate at the age of 16. But without that, they will not be able to get married in the church that they wish. For example, sort of, if the Church of Scotland regularly marries transgender people and their spouse, but it might be that the minister that they have wouldn't be performing same-sex marriages. So at the moment there is discrimination against 16 and 17-year-old transgender people, and we think that it's not controversial really to enable people to make their various decisions about their life at the age at which Scotland recognises them to have legal capacity to do so, which is 16.
You twice mentioned the term parental support.
Yeah.
Can you explain it? Is that pivotal to the process?
Yeah, basically, in order to transition at a young age, you would need your parents' support as well as the support of a child and adolescent psychiatrist specialised in gender identity issues. So this isn't something that a young person can just decide and go forward with on their own. They would be very, very carefully assessed, and only where they were very well supported would they be able to have changed their name, their school records, their NHS records, which is all what would be required to show as having been done at least 2 years before any gender recognition certificate is issued.
For that, thank you. Thank you.
Can I actually bring in Brandy Lee, please?
Young people are aware of their gender identity far earlier than they're aware of their sexual orientation. We work with a number of trans young people who have already begun the transition long before the age of 16. Therefore, we consulted with trans young people in our service, and we found that a large number of them were very upset by the fact that they could leave education at 16, they could acquire a job, they could get married, but yet they couldn't legally have their gender recognized. For them, this was a very large disconnect. I have a quote from a young person about that. I'm currently 17 and am going away to college next year. I would much prefer to have myself as male on all the official records, but they need to have my real details on the system. Further, we asked young people in our consultation if the age of GRC at 18 at the moment had stopped any of them from entering into a marriage. And we do have several young people who said that, yes, they had delayed marriage in order to receive their GRC. Because if someone enters into a marriage at the age of 16 and they have to wait for a GRC at 18, they would then have to re-register their marriage afterwards if the bill passes. If the bill didn't pass, they wouldn't have the option. One young person said, I'm 18 and am currently engaged. My partner and I have been engaged for approximately 1.5 years now, and although we were both very keen to be legally married, we had planned to do so in the summer following our engagement. However, as the age of GRC is 18 and at the time we were 17, we couldn't get married. Changing the age of GRC to 16 would have made a huge difference. My partner and I could have been married when we had originally planned and begun our lives together.
Thank you. Marco?
Yes, I'd be interested in a religious perspective on gender transition and how you view that within your own congregations, Mr. Phillips. You've been sitting quietly, but you get a question here. You're not getting off with it.
The situation in the Society of Friends is that we see God within each individual person. We would look at each individual couple individually and try to think, what is the right approach for that couple? We would help them with marriage preparation and relationship preparation, irrespective of their gender or their sexuality. So really that is a question that, firstly, it has not arisen, and secondly, I cannot imagine it giving us a problem.
Okay. Do you want to ask your questions now on civil partnership?
Yes.
Yep.
Well, to a great extent, civil partnership's been covered in terms of your perception of the difference between it and marriage, but in what way has attitude to civil partnership changed, if any, since it was introduced? Because at the time it was welcomed, and now organisations are looking for more. And can you just explain that change?
First of all, I was actually looking back through meetings that we've had with this committee in the past, and I discovered that we'd come to give evidence almost exactly 10 years ago in October 2003 about exactly this question, because the committee was taking evidence on the Scottish Government's then consultation about introducing civil partnership. And I discovered that what we'd said then was that we thought that civil partnership was the right thing to introduce, that it was something that would be of huge benefit to same-sex couples because it would allow them for the first time to get a legally recognised relationship and give them the legal protections. But we also said that it wasn't equality, that it would be a separate but equal system, and that in the medium term, the only thing that would be true equality would be to open up marriage to same-sex couples and also to open up civil partnership to mixed-sex couples, because the two are different and we think the same choices should be available to couples regardless of gender. We said back in 2003 that we thought it would take several years for there to be a discussion, a public discussion, a discussion with politicians about opening up marriage to same-sex couples. That was 10 years ago. Those several years have now passed and more. There's been very wide discussion about opening up same-sex marriage, both publicly within this Parliament for 4 years now. And so that's why we think now we're in a different situation from where we were 10 years ago. 10 years ago, it wasn't time for same-sex marriage. Now we think it is time.
Mr. Macfarlane?
And just back to the points that I made earlier, I think it's about that distinction between how society views gay people. I think Tim's right, 10 years ago we thought civil partnerships would erode some of those distinctions, and that the public discourse around how society views gay people would shift and would change. But I go back to the hard evidence that I've shown you. 216,000 had seen homophobic bullying in the workplace. Our children in our schools are still suffering some form of homophobic abuse. That distinction hasn't shifted. And I think we've come very much to the view, and gay people have very much come to the view now, that until they are seen as equal in the eyes of the law, which this bill would do, it would cement that legality in the eyes of the law, it would infer the same rights and the same responsibilities on gay people that their straight friends and family have, that distinction won't be eroded. And that's why this bill is so important now in terms of moving and shifting that distinction. And we firmly are of the view that this bill would be the vehicle to change that perception in society. I think Tim's absolutely right. It's about how gay people are seen in society, how that discourse happens in society. And until you're seen as equal in the eyes of the law, that distinction will still remain and won't be eroded.
Can I ask then, how does that reconcile with the opt-in approach in the bill, whereby certain religious organisations, indeed any religious organisation that wishes, will be able to not opt in and therefore continue with their practice? Are we going to see in 10 years' time you coming back and saying that things have evolved and they should be required to opt in?
I think the opt-in is right, and I think the balance is right within this bill. I don't think it's for any of us here in this panel to tell a religious organisation what they should do. That's for the religious organisations, through discussion, through prayer, to come to that conclusion themselves. I can't see a time when we would be asking any organisation who still didn't want to carry out same-sex marriage to carry out same-sex marriage. The purpose of this bill, and the way the bill has got it right, is around the freedom of speech and the freedom of religion. What's brilliant about this bill as well is it's allowing those organisations who wish to allow same-sex marriage that opportunity. It's not right for one religion to tell another religion whether they should be allowed to carry out same-sex marriage. So I think the opt-in system is absolutely right, and I think that permissive system gets it crucially right. And again, the Scottish Government should be applauded for that.
I would agree with that. And I think one of the things that's changed over the last 10 years is that a number of religious organisations, including the Quakers, I think in 2009, have decided that they do want to conduct same-sex marriages. You asked what things would be like in 10 years from now. Possibly some of the other churches will have decided in 10 years' time that they want to conduct same-sex marriages. But that, as Colin says, that has to be a decision taken by the churches, within the churches. And I think we can rest assured that that is the way things will go. If you look at one other area of discrimination law, sex discrimination law, which the laws have been in place now for about 40 years, discrimination on grounds of sex is not allowed, but it is allowed for religious bodies. Religious bodies, like, for example, the Roman Catholic Church, are allowed to employ only men as priests. Over those 40 years, there have been no moves to try and force through the courts the Roman Catholic Church to employ women as priests. Everybody understands that it's up to each individual church to decide whether or not they want to open up their ministry to women. and those decisions are rightly made within the church. Now, some people have said that this bill provides a balance between equality on grounds of sexual orientation and better equality on grounds of gender identity, balanced against religious freedom. I think that's the wrong way to look at it. It's not a balance of these two things against each other. The bill actually promotes both at the same time. It increases sexual orientation equality and it increases religious freedom by allowing religious bodies such as John's to conduct same-sex marriage, but completely protecting the right of religious bodies that don't want to conduct same-sex marriages not to do so.
On this one. Can bring Siobhan in first and then yourself, John.
Thanks, Convener. Mr Hopkins, this isn't meant as an inflammatory comment. It was just a bit of clarification because you said about the civil partnerships in your answer to Marco that it wasn't time 10 years ago and it is now. And yet in submissions that we've had, equal marriage is seen as the same as the civil rights movement. That's been equated to by some people. Now, of course, we wouldn't have said at any point that it wasn't time to have equal rights for those of different races. So I'm just wondering about that, if you could expand on why it wasn't time then. If it's about equality, surely it's always time to do what is right.
I mean, I think that may relate to the way that we as an organisation work. I mean, we try and work in a consensual way. We try not to work in a way that's embattled, if you like, that sets us up against other organisations. So I think we had a recognition 10 years ago that same-sex marriage was then quite contentious. You know, in 2002, when we developed this policy, only one country in the world, the Netherlands, had same-sex marriage. A lot of countries had civil partnership. Now, all of the countries surrounding us in Western Europe, apart from Ireland, do already have same-sex marriage, and the Irish government is working on it. So the whole context has moved on. Public opinion has moved on. Back in 2002, the Scottish Social Attitudes Survey found that 41% of Scots were in favour of same-sex marriage. By 2006, that had risen to 53%, and by 2010, it had risen to 61% of Scots in favour of same-sex marriage, with only 19% against. So, you know, we do try and work in a consensual way. The other factor is that when this Parliament was set up 14 years ago, we had in effect quite a long list of legislation which discriminated against gay people, against LGBT people, and against same-sex couples. For example, a different age of consent for sex between men, Section 28, which needed to be repealed, the fact that there was no recognition in law of cohabiting same-sex couples, the fact that adoption and fostering were not available to same-sex couples, the fact that sex offences law discriminated against same-sex couples, there was no hate crime legislation, etc., a long list. And we've been addressing those, and to the credit of this Parliament has been addressing those one by one. Now, this is the last one. In terms of sexual orientation equality, this is the last big area in which the law still discriminates against LGBT people. And we think, actually, if the Parliament passes this bill, which we very much hope it will, then this Parliament can be very proud of the way the situation has been turned around in the last 14 years, and the very substantial discrimination that LGBT people felt and faced 14 years ago has finally been eradicated from the law.
Thank you. Just on the points that Mr Macfarlane made, obviously the Living Together report that you mentioned, and obviously you've talked about the workplace bullying as well. I'm more familiar with the Living Together report. You equate people who have said that, of course, we should tackle homophobic behaviour in schools, and saying that people of faith believe that that should happen, and I believe that's the case. But do you see that actually there's two separate things at the moment, that actually the people who support that may not necessarily support equal marriage, but that doesn't necessarily mean that they don't support the action in schools? Do you see that as two different things, or do you see it as one?
Do you mean in terms of teachers, or are you meaning in terms of...
Just general public. So, of course, people want to tackle homophobia and bullying in schools, and your report correctly says 92% of people wish to do so, and I believe that's true. Those same people may not necessarily support equal marriage. Do you see that in your own studies, or? Yeah, I mean, let's be very clear that those people who don't agree with equal marriage aren't necessarily people who agree with discrimination against LGBT people. We've always made that distinction. Just because you don't believe in equal marriage doesn't make you, for example, homophobic. We've always said that. We've always been very clear. But I think there's another issue around there as well, which is until
you know, if you've got people saying, yeah, we believe that LGBT issues should be discussed in our school classrooms, that's a way to tackle homophobic abuse. We clearly believe that those people of faith believe that too, and that's, you know, as you said, that figure is there. So we're not saying that you cannot support moves to eradicate discrimination against LGBT people. It's not compatible with your view that you don't support equal marriage. We would never say that, you know, that you must support equal marriage, and therefore that means that you therefore are trying to eradicate discrimination against people in schools. There will be people of faith who clearly think that any discrimination against LGBT people is wrong, but their faith says to them that they don't believe in equal marriage. That doesn't mean that they are homophobic in any way, shape or form.
Can I bring John Mason in now?
Thanks very much. Yeah, it was to follow up a point that Marco Biaggi was making about the kind of movement over time. And in fact, I think Mr Hopkins, you mentioned adoption as in amongst all of these other things. And that's an example where something has been permissive to start with and then has become compulsory over time. Because originally, I think the suggestion was that there should be adoption agencies would be able to place children with same-sex couples, and there were assurances given that agencies that did not agree with that could continue to operate in their own way and perhaps refer to other agencies. But over time, that has changed, and we now have a position where agencies are compelled to place children with same-sex couples or they lose their charitable status. So that would be a fear, and do you recognise that that's a concern in this area as well, that we start off by permitting same-sex marriage, but then it becomes compulsory?
I do recognise that the issue of adoption agencies has been raised. The situation, I think, is not quite as you've described it. Two pieces of legislation were dealt with at the same time, around 2007. One was here in the Scottish Parliament, and that was the legislation that allowed same-sex couples to apply jointly to be adoptive parents. That's a devolved matter. The issue of what the law says about bodies that provide public services with public money discriminating on any ground, be it religion or sexual orientation or any other ground, that's a reserved matter. And that was dealt with down in London at Westminster, and specifically in this case it was dealt with in the sexual orientation regulations that were passed by Westminster in 2007. Now, Westminster debated very carefully, specifically, the issue of adoption agencies and whether it was valid for adoption agencies to simply turn away all same-sex couples. And concluded, both Houses of Parliament concluded that no, they shouldn't do that. And the reason is that adoption agencies provide services using taxpayers' money. Councils pay adoption agencies to match up prospective adopted parents with children. So taxpayers are paying for that, and the view taken by the Westminster Parliament, which I agree with, is that where public services are being supplied and paid for with public money, because we all pay our taxes, whether we're heterosexual or lesbian, gay or bisexual, then those public services should be made available to everybody. That is why adoption agencies are required to allow same-sex couples to apply to adopt. Of course, there's no right to adopt. Everybody is put through a very stringent vetting process before they're accepted as adoptive parents. So when the debate was happening here in the Scottish Parliament, if you look at the Stage 3 debate on the Adoption on Children Scotland Bill, you'll see that the Scottish Executive specifically referred to the fact that it was the Westminster legislation that was then under consideration, which would determine whether or not it would be valid for adoption agencies to simply turn away all same-sex couples. So, in fact, the situation hasn't changed since that legislation came into effect, with one proviso. The Westminster legislation about adoption agencies, which said there shouldn't be discrimination, came into effect in April 2007. But because some of the religious adoption agencies, religious affiliated adoption agencies, had said we need time to adjust to this, the Westminster Parliament agreed to allow a period of 20 months for those adoption agencies to make that adjustment. So actually the rule that adoption agencies should not discriminate came into effect at the end of 2008. Now, the adoption legislation in Scotland that allowed same-sex couples to adopt didn't come into effect until, I think it was 2009. So actually the rule applying to adoption agencies was already in place. before it became even possible in Scotland for same-sex couples to adopt. So things haven't changed since that legislation.
The you're making is that with adoption, it's a public service and it's paid for by the public, whereas marriage is a public service, but it's not paid for by the public.
No, I would not call marriage a public service. As far as marriage that is done by religious bodies, it is a religious function. It's a sacrament as far as some churches.
It's part of the legal system?
Pardon?
Surely it is a public service. It's part of the legal system.
It's recognised in law, but it's clearly a religious function. And in fact, you know, the Equality Act amendments that are there, that are going to be introduced when this legislation, if and when it passes, make it clear that that is a religious function of churches.
Okay, thank you very much. Christian, would you like to ask your questions?
Yes, thanks very much for coming. What I would like to talk about, maybe Tim Hopkins spoke a lot about what's happening in other countries and down south. Maybe the other members of the panel want to tell us more about what they think about the legislation we are introducing here at Parliament. And if you compare with other countries, we know that the Constitution started in 2011. A lot of things have happened the last 2 years. And I would like to have your views on what you think has happened in other countries and what the consequences will be for this bill in Scotland. Particularly a more technical point. I would love to know what your views are on the issue that may arise for couples who have a foreign civil partnership but wish to marry in Scotland.
First, Tim.
In terms of what we expect the effect of this legislation to be in Scotland, currently about 500 couples per year in Scotland enter civil partnerships. And the consultation we've done with LGBT people suggests that the majority of those will actually choose a same-sex marriage rather than a civil partnership. So those are the kind of numbers we're talking about. We'd also expect, by the way, we would hope, in fact, that a fair number of foreign same-sex couples will come here to Scotland to marry. Something like a quarter, just under a quarter of all marriages in Scotland at the moment are between people who don't reside in Scotland at all. They're what's called tourist marriages. And that obviously helps the Scottish economy, and we very much hope that will be the case with same-sex marriages as well. Now, anybody can come here from any country in the world and get married, so that will be the case with same-sex marriages as well. It doesn't matter whether your home country recognises same-sex marriage. There is, however, an anomaly in the bill, and it relates to the changing of civil partnership into marriage, and you asked about this. Under the bill, you can change your civil partnership into a marriage either by an administrative route, where you apply to the registrar and say, please change my registration from civil partnership to marriage. That's only available for people who registered their civil partnership in Scotland for obvious reasons, because the registration to be changed is there on record. But the other way that you can change a civil partnership to a marriage under the bill is simply to marry in the normal way. At the moment, the bill says you can only do that if your civil partnership was actually registered in Scotland. And that's causing real problems for a small number of people. We were contacted by a couple, one of whom is American and the other is a British citizen. They lived for a while in New Jersey. While they were in New Jersey, they entered a civil partnership in New Jersey, and they've now moved back to this country and living here permanently. They're recognised as being in a civil partnership. They would like, when this bill is passed, to change that to a marriage. And had they registered their civil partnership here, they'd be able to do that. But because their civil partnership is registered in New Jersey, under the bill as it stands, they can't get married in Scotland when this bill passes. First of all, they have to dissolve their civil partnership. That will be the only way that they will be able to marry. The problem is that to dissolve a civil partnership, you have to show that your civil partnership is irretrievably broken down. It's the same rules as for divorce. And of course, theirs hasn't. The only way they could dissolve their civil partnership would be to live apart for a year. So you have here a couple who are in a civil partnership. They want to change that to a marriage, as the bill would allow, had they registered their civil partnership in Scotland. But because they've registered the civil partnership in New Jersey, if they want to get married, they first of all have to split up for a year, which is a nonsense. Effectively, they're barred from getting married. So it's a small number of people affected, but it's real people, people who registered a civil partnership abroad, who, as the bill stands, will effectively be barred from entering a same-sex marriage. We think a small change should be made to the bill to allow people to get married in Scotland if they're already in a civil partnership, but to extend that to civil partnerships registered anywhere.
There's also a particular issue for transgender people in this regard. because if you're not able to convert your civil partnership that was registered in a foreign country into a marriage, then you're not going to be able to get gender recognition without the state inhumanely forcing you to end your civil partnership and all of the trauma that exists around that. So the people who are living in Scotland with a foreign civil partnership would remain the only couples where the inhumane divorce requirement would still apply after the bill for transgender people in that situation. So it does have a particular discriminatory function on transgender couples.
Just come in this and say that if the couple were to split up for that period of a year, and if anything happened to either or of the partners, then they wouldn't be entitled to any of the inheritance that would relate to that person. Is that correct?
They would, during that year period, they would, because they'd still be in a civil partnership.
Right.
The year is effectively a waiting time for you to
Mm-hmm.
get your, in this case, dissolution of civil partnership, just like divorce. The problem arises in the period between when they get that dissolution and when they then, it might be a few weeks later, enter their same-sex marriage, because for that period of time they don't have protections because they'd be regarded in law as unmarried. So you're quite right to identify that there's a very practical problem there, and it happens in that period.
Okay. Would anybody else comment?
Yep, there's also issues in regards to immigration status, because in order to make sure that you can live in Scotland with your partner, the immigration services would need to be satisfied that you are truly a couple. And so all of this kind of having to split up and get back together could easily sort of result in immigration services being less than convinced that everything is above board.
Anyone else? Colin?
Briefly, I think there's also the human factor around it. The very fact that you might be in a loving, committed, stable relationship and then you have to split for a year is really particularly cruel. But our view very much is a small number of people, but as Tim says, they are real people, and the bill should be amended. It could be very simply done, and we agree with the principles that Tim's been saying.
Okay, thank you. You finished? Yes.
Introduce some of the members of the panel to ask this question about the views and the anticipated demand for the religious and belief registration of civil partnership if and when same-sex marriage will be available.
I'm sorry, I didn't quite follow the question, but I understood that you wanted clarification about when we would introduce these.
No, I just want to project ourselves in the future and to see that we did that with Tim Hopkins' answer regarding if the bill is passed. Do you think we will have a lot less demand for religious and belief registration of civil partnership and people will opt more for a same-sex marriage?
Thank you, I understand. I wouldn't want you to get the impression that the Society of Friends was not delighted with civil partnership legislation when it was introduced. We saw this as a really significant and important step forward in equality. It's only through experience that we have learned and begun to really appreciate that same-sex couples feel that it actually makes them different in a way that we are unhappy about. We wish for inclusivity. So as far as we're concerned, we very much want to opt in to being allowed to conduct same-sex marriages, and we're absolutely convinced that when we have done that, there really won't be a demand among our congregations for civil partnerships, because we know that that is what they have been seeking. Nevertheless, in terms of equality generally, we applaud the general steps that are taken by the measures that have been put forward by the Scottish Parliament, because they give all options to everybody, really. And that seems to us to be right, although I don't think it will apply in our specific case.
Could Brandy come in on this, please?
I would just like to add that the LGBT National Youth Council has been campaigning on the idea of equal marriage since 2009. Under their concept of equal marriage is opening up same-sex marriage, or opening up marriage and civil partnerships to all couples. So not just focusing on adding same-sex marriage, but adding civil partnerships to mixed-sex couples as well, particularly for some of the issues that we talked about in terms of bisexual couples and trans people who don't want to pursue a GRC, then being limited to either having one sort of relationship or another, depending upon their birth sex, for instance. They also feel that it's a matter of equality. If couples cannot choose between marriage or civil partnerships, some couples would rather have a marriage to recognize what they feel is their relationship in relation to society. Other couples would rather have a civil partnership to signify that. And for LGBT young people, same-sex marriage as well as mixed-sex civil partnerships are very important issues, and they're issues of equality.
John.
Can I come in on that?
Well,
I take that point, but the experience in Sweden and Denmark was when they legalised same-sex marriage, they found that civil partnership, their equivalent of civil partnership, was redundant, and they ceased to offer it to any new entrants. I'm not sure entrance is the right word, but you know what I mean. And that arose from a view that civil partnership was created purely as a compromise to prevent giving equal marriage at that stage, and that it was now useless. Now, why really is there still a need to continue with civil partnership after marriage is equalised, if it indeed is?
Have a mic on, please.
Yeah.
So we consulted with LGBT young people in 7 youth groups, and we consulted with 2 schools around the draft bill, and we asked them several questions about issues in relation to education as well as in regards to mixed-sex civil partnerships. And we asked them, if mixed-sex civil partnerships are not introduced, how will this affect you? And I do not have the quotes, but I can send them afterwards. But there were a sizable number of responses that said that young people, A, would not have a relationship status that would represent their ideals. Some don't want to identify with the idea of marriage, which has thus far excluded them, and they would rather choose an additional option. And others feel that actually, even if they were not to choose civil partnership, they would choose perhaps a marriage. The idea that couples could either choose marriage, some couples could choose marriage or civil partnership while others could not choose civil partnership was unfair. And for them it was a matter of opening all options up.
I accept that it's unfair to have one couple being offered marriage and one being offered marriage and civil partnership, but why is there a need to have civil partnership offered to both rather than to neither? Simply
because some of the young people that we spoke to prefer a civil partnership, and that's what they would choose when they reach that age.
Colin.
If I can move away from the idea of mixed-sex civil partnership for a minute, the bill is allowing the religious belief celebration of civil partnerships, and we agree with that, primarily because there are some LGBT people of faith who don't necessarily want to marry for whatever reason, but they want to have the option of civil partnership. We don't know yet what the effect is going to be of this legislation on civil partnership. The Scottish Government have announced a review in civil partnerships. We think that's a pragmatic and sensible policy decision to make. And until we have hard evidence to suggest either way what might happen around civil partnerships, I think the idea that civil partnerships are going to be open in terms of religious belief blessings of the civil partnerships is a good thing. So I don't think we know yet what the evidence is going to be, and I think we should wait for that review, that Scottish Government review on civil partnerships, and we look forward to seeing what that review comes forward with.
Okay.
Very briefly add, Marco Biaggi mentioned a couple of Scandinavian countries which abolished civil partnership for new entrants, as you put it, when same-sex marriage was introduced. And that's one way to go, but there are equally a number of other countries who chose to retain civil partnership alongside marriage when marriage was open to same-sex couples, and they include France, Belgium, the Netherlands, New Zealand, South Africa. In the Netherlands, the situation is quite similar to what we would like to see here, which is that civil partnership and marriage are both available, and they have very similar legal effects, but they are different and they're seen to be different. And if you look at the stats in the Netherlands, you find that about 1/4 of same-sex couples choose a civil partnership rather than a marriage, and 3/4 choose marriage. Amongst mixed-sex couples, it's about 90% choose marriage, but 10% choose civil partnership. Now, our surveys of LGBT people in this country have found similar proportions for same-sex couples. So about 1/4 of same-sex couples who are not currently in a civil partnership have said to us, well, in future, we'd actually like a civil partnership, not a marriage. They would prefer that for the kind of reasons that have already been touched on, whereas 3/4 would prefer a marriage. So I wonder, actually, even in countries like Sweden that have abolished civil partnership, to what extent LGBT communities in Sweden wanted that to happen. Clearly, it was a decision of the Swedish Parliament. I would guess that had civil partnership been retained in Sweden, that you'd find a similar minority of people wanting to enter a civil partnership. So we simply think it's about maximising choices for everybody. Now, ideally, we would have liked to have seen mixed-sex civil partnership in this bill, but there's a lot in this bill already, and there needs to be consultation and discussion about the future of civil partnership. Should it be opened up to all couples regardless of gender, or should it be got rid of, as happened in Sweden? We very much welcome the Scottish Government's review that was announced in June. We think it's important that review starts soon. It's taken 2 years to get to this bill from the consultation starting on same-sex marriage. We very much hope that in 2 years' time, some of us might be back here talking about a piece of legislation which opens up civil partnership to couples of any gender.
Thank you, John. Yes.
Okay, back on to kind of really the area of protection for those that disagree. Again, in the Equality Network submission, it talks about, I think you're agreeing with the government's plan that people, say, on the periphery of marriage, like chauffeurs and photographers, hasn't got a page number, should not have the freedom to choose not to take part in a same-sex marriage. I mean, is that not just moving the discrimination away from the LGBT community onto the religious community?
I'd like to say a couple of things about that. The first is that the situation won't change at all. Wedding photographers are already required by law not to discriminate against civil partnerships. So it's already the case that, you know, if you are a commercial organisation selling photography services, you must not discriminate on grounds of religion, on grounds of gender, on grounds of race, on grounds of disability, and on grounds of sexual orientation, which means you must provide your services for civil partnerships. So
and we all agree with it, though.
Right. Okay, so I accept that there will be differences of opinion about that, but the point I'm making there is that the law is not changing. The reason we think the government have got it right is we think there is a difference, as I said before, between the operation of religious bodies and the provision of all kinds of religious services by religious bodies, and the provision of commercial services or employment by somebody that has a personal religious belief. We don't think it's appropriate to allow somebody's personal religious or philosophical beliefs to give them an opt-out from anti-discrimination legislation as, for example, an employer or as a commercial business selling services to the public. Where would we end? You know, if somebody has a philosophical belief that is strongly against mixed-race marriages, are we saying that that person should be able to refuse to supply services to people who are entering a mixed-race marriage? Are we saying, for example, that public servants, the people who empty my rubbish bins, are they going to be allowed to say, well, I strongly disagree with same-sex marriage, therefore I don't want to empty the rubbish bins of people who are in same-sex marriages? I don't want to sound flippant, but all of these are examples of sexual orientation discrimination that the law says should not happen. We're very clear that if a business is supplying commercial services to the public, where public services are provided to the public using taxpayers' money, and where non-religious employers are employing people, then every member of the public, every employee, should be treated with respect. And I actually believe that the large majority of people would not have a problem with that. You know, I may have a religious or a philosophical objection to a number of things, but that doesn't mean that I will treat my colleagues at work or the people I'm selling food to if I run a food stall with disrespect and refuse to serve them.
I think there's two things there. I mean, one is respect, one is refusing to serve. I would not accept that the two are necessarily the same, but we can leave that just now. But I mean, what about the model we have in the NHS that for abortion, which is similarly a very controversial subject, it's specifically in the legislation that there is protection for those that do not want to take part. And that's been relevant because it's been used in court cases quite recently. Now, is that not a good model of a kind of pluralistic society where the public sector pays, but services can be provided in different ways to fit in both with the employees and with the public?
I don't think that same-sex marriage can be compared to abortion. You're quite right. Of course, there is a conscientious objection route for people who work in the health service who disagree with abortion. There's also a similar route for people who have a conscientious objection to fighting in the armed services in wars. Now, why are those objections, why are those routes provided? It's because if you have particular religious beliefs about abortion, then if you're asked to be involved in one, you're being asked to be involved in murder. And the same is true for people who have a conscientious objection to fighting in armed services during war. So those opt-outs are there so that people are not required to be involved in committing a murder by their own beliefs. That is a very different thing, for example, to asking a civil registrar to sign off on a civil same-sex marriage. Civil marriage ceremonies are not allowed to include any religious content, so religion doesn't come into it at all. The registrar is simply there to conduct a completely secular ceremony and then to sign the piece of paper to acknowledge that the couple have said their vows and have signed up and that their witnesses have signed as well. That is not comparable. Asking somebody to do that is not comparable to asking somebody to commit murder. And so we really think it's quite reasonable to say that civil registrars should be expected to sign off on same-sex marriages, just as a civil registrar who, for example, holds Roman Catholic beliefs against divorce, believes that divorce is wrong. Those registrars are not allowed to refuse to marry divorced people, even though they may believe that divorce is wrong. We would say that civil marriage is an entirely secular, non-religious function, and that civil registrars should provide that function to all couples, regardless of their personal beliefs about those couples' lifestyles.
I bring Colin in very briefly, and then I've got one final question to be asked.
I mean, I agree with Tim. I think the comparison between long-term committed loving relationships or gay people's long-term committed relationships with abortion, I think most gay people listening to that would be really hurt and quite disappointed that comparison's there. But I'll just reiterate what Tim says. If you're looking at it in terms of public services, registrars are performing a public service paid for by the public purse. LGBT people pay their taxes in the same way as everybody else. They deserve and expect exactly the same standard of service, be that good service or a bad service, but the same standard of service as everybody else. And again, Tim is right. It's a Pandora's box. As soon as you have an opt-out on one area, such as same-sex marriage, you can then start having questions around opt-outs about people who have issues around mixed faith marriage or mixed race marriage, and as Tim also clearly stated, around those who might have objections to divorce. The fact is this: they are providing a public service paid for by the public purse, and everybody, including gay people, deserve exactly the same standard and level of service as everybody else.
Okay, thank you very much. Can I move on to Jim? Can I ask everyone that's going to be answering the questions if you can keep it short, because we're now running out of time. Thank you.
Thank you for the opportunity to attend and participate this morning. Can I thank you for your evidence? I think it's been incredibly enlightening to hear your evidence this morning. I just want to, as a point of clarification, ask about the importance of the legislation for ensuring transgender equality. That's a point that's been made very forcefully this morning, and in answer to questions from Mr Biaggi and Mr Finney, you took us through the specifics of that, Mr Morton. You talked about the spousal veto, gender recognition certificates, and the evidence requirements for people who were transitioning to a new gender over quite an extended period of 6 years and more, and then talked about the age of application to the gender recognition panel. But notwithstanding those concerns and the further modifications to the bill that you are seeking, are you largely satisfied with the provisions of the bill which allow for an administrative procedure which would allow marriage certificates to be updated to reflect a new gender without there being a new marriage ceremony? And can you tell us why that is so important?
Yes. For transgender people and their partners who are wanting to get an updated marriage certificate following gender recognition, it's really important that they're not required to go through a ceremony, because they feel that their marriage is continuing. It's not a new marriage, and the fact that it's continued throughout the very difficult experience of one party transitioning is of prime importance to them, and requiring them to go through a ceremony would be deeply offensive to them. The whole point of removing the requirement to divorce for gender recognition is about recognising the continuance of those marriages and the right for those marriages to continue. So having an administrative function is to update the certificate is very important to transgender people. I'd also like to add that from a transgender perspective, civil partnerships were never satisfactory. They never removed the problems with the lack of same-sex marriage for transgender people. So from the start of the work to try and achieve gender recognition and the Gender Recognition Act 2004, transgender people were always of the view that their marriage must be able to continue, and that they basically it shouldn't matter what the new gender status of one party is. The fact that that commitment for life has been made in the marriage is what counts. So we're very pleased that that's being recognised within the bill. We are aware, though, that we hope that the committee will take time to look in detail at the transgender amendments, because at the time that the draft bill was being consulted on, those were still the transgender parts were still being finalised. They weren't fully available at the time of the draft bill consultation. So there is still those improvements needed. They're not as refined yet as the changes to the likes of the Equality Act and things like that.
No, it isn't. Are you okay, yeah? Is anybody else like to comment before we close the meeting?
Raise very quickly one issue, Convener. It's referred to in the last couple of pages of our written submission. We'd identified what we think are potentially 3 slight technical errors or omissions in the bill. They're not matters of policy. They are simply about the wording in the bill we think not being quite right. I'd be very grateful if the committee thinks it's appropriate, if the committee could perhaps ask the Scottish Government about those, see if they could be put right.
Yeah. Okay, thank you very much. And very briefly.
I will be brief. I just want to note, in terms of education, we spoke about registrars providing a public service. Teachers are also providing a public service, and I just want to highlight the fact that teachers need to provide, according to the GTC's Code of Professionalism and Conduct, they need to be committed to social justice and inclusion, and that includes social justice for all young people in education, recognizing that the legislation in the country and the commitment to inclusion that includes LGBT young people in education. There's also Article 12 and 13 of the UNCRC for young people, the right to have a say in decisions that affect them, and the right to receive information that's relevant to them. That is very key, because we know that when LGBT young people do not see themselves in the curriculum, they feel excluded, they do not feel like that they can achieve, and they're much more likely to experience homophobic, biphobic, and transphobic bullying. The final thing is that GERFEC also promotes safe, healthy, and responsible, all of the indicators, but particularly safe, healthy, and responsible individuals when there is inclusion of all identities in society in educational teaching. Thank you.
Thank you. And finally, and very briefly,
point that Brandalise made around education. At Stonewall Scotland, we work with hundreds of schools and hundreds of teachers across Scotland. Not one teacher has raised a concern with us around about discussing same-sex marriage in the classroom. But what many of those teachers have said to us is that they've been worried about some of the debate that's been going around marriage, talking about opt-outs and talking about conscience clauses within education. They are very frightened and are very worried about the fact that that will see a return to the days of Section 2A in our classrooms. And they are very, very clear that they do not want a return to those days. And I would say probably that every single member of this committee panel wouldn't want to see a return to those days when same-sex issues and relationships cannot be discussed in our classrooms, because those days cause so much hurt, so much harm to so many people.
Thank you very much, and thank you all for coming along this morning and giving us the evidence. And we'll now suspend the meeting to allow our second group of witnesses to take their seats. Thank you very much. We're just actually waiting for our final Good morning, everyone, and I'd like to welcome our second panel of witnesses. We're just waiting on someone just now who I think's just walked through the door. And if I could ask you all to introduce yourself before we actually begin with Dr.
I'm Salah Beltagi. I'm from the Muslim Council of Scotland.
Good morning. I'm Dr. David Easton, the head of the Methodist Church in Scotland, the chair in my first week in this post, and I'm here representing the Methodist Church in Britain.
Good morning. I'm John Deegan. I'm from the Catholic Parliamentary Office, which is an agency of the Catholic Bishops' Conference of Scotland.
Morning. I'm Kieran Turner. I work for the Evangelical Alliance in Scotland as their Public Policy Officer.
Okay, thank you very much. Could I also say that we do have the Parliament photographer here who will be taking some photographs, and also if any of the witnesses have any other questions and you want to come in on the questions that's actually been asked, please indicate to myself and I'll include you in that conversation. Okay, and we'll start with Alec.
Thank you very much, Convener. Now, having read through the bill and the evidence, it's very clear that each of the organisations or groups of organisations you represent are offered a protection from this proposed legislation. You effectively have to opt in. Why are you worried about this legislation?
We're actually worried more about the principle itself than the protections. The principle of marriage and what it means over the history of mankind and the whole build-up and history of marriage being something to create a family and the importance of having a family based on the complementary of the male and female father and mother. In fact, I'm thinking that the whole physical world is based on this polarity of things, from the atoms, the cells, to the human being. And that's really our main objection. The protections which are offered by the bill, we've collected evidence from many sources, and all goes towards that these protections might not be sustainable when it goes further to higher courts like the European Court of Human Rights and so on. And we have seen experiences like this. But as I say, it's really the principle which is really worrying us to change the whole history. And one part of the bill talks about changing the legislations and the text of the law, Scots law, etc., to accommodate a change for the bill. Are we going to do this for the whole documents which we have in our history as either faith groups or nations, so that when we read a document now, we understand that what is meant by marriage in that document is what is meant by marriage at that time, not what is now. Of course, if we adopt this, the next thing, we will not distinguish between these two. So we get a completely different picture of what is being said at the time and what's being recommended at the time according to the new definition, which is different. And then it's like, changing the interpretation of everything we have in our heritage.
To contribute?
Yes, please. I think Salah does get to the point that it's a point of the principle is the bigger question, but in terms of the opt-in and the protections, that is fair enough. And I think the panel earlier were right that there are substantial protections around the celebration of a ceremony of a marriage. I don't think they will be fully robust. I think that the panel earlier didn't get to the crux of the matter, that a religious celebrant is providing a public service. So I think there will be avenues at which that could be challenged further down the line. I believe that it has happened in Denmark, I believe, where a church has been told that they must provide religious celebrants. So I think there will be a challenge there. The broader issue is that this, there is a fundamental philosophical clash of opinions here. There is a view that marriage is just a loving relationship between any two people that have committed themselves to each other. And then there is the traditional view, which is upheld by the Catholic Church, most of Christianity throughout time and most of Western civilization, that marriage actually centres around the fact that we create an environment to ensure that children have parents. That's the fundamental difference. We think if we, our grave concern is that if we change the law as proposed, we will obscure that particular understanding. So this is a question that won't satisfy everyone. We was talking earlier that this gives everyone the right option. This is not. This is about how society, not just religions, how all of society understand marriage. Is it something that's about protecting children and ensuring that their parents are bound together in marriage so that they're there to bring up the children, or is it just a relationship between a form of friendship? We believe it's the former of those, and we think for the common good of society and for children particularly, we need to state that as a society and to protect it. That's about to be lost.
Can I bring Marco in on this, please?
Sure.
Yes, do you have any quantitative evidence that that is the perception of the majority of people in Scotland, that marriage should be for the purposes of procreation? Because we do, after all, have Scottish social attitudes evidence that a majority believe that same-sex marriage should be acceptable, so it would seem hard for those to be squared.
Well, I think that the biggest survey, really, the biggest the most profound probing of public opinion was when the government did its consultation, and they received 77,000 responses to that. So I think that's way greater than any other survey, which typically would use 1,000 people. That also was engaging people who really thought about it. I think we do live in an age where, and I have this approach myself, we are in a let live society. We want to, if people want something, by all means let them have it, if it doesn't impact on the rest of society. So I think from that 77,000 people responded, 64% of those responding within Scotland said that they thought same-sex marriage shouldn't be approved, we shouldn't redefine marriage. So I think there is quantitative evidence on our side of that. Broader than that, I think the issue hasn't been thought through as well. I think the consequences, you know, it's often an emotive issue, and we don't want people to have hurt feelings, and it's often a focus on people feel hurt or they feel embarrassed or humiliated because their relationship isn't given a particular status. We believe that we have to have a rational basis about why do we have marriage. You know, there's lots of friendships that should always be valued. Every friendship should be valued in society. But why does the state take an interest in that particular relationship between a man and a woman? And we fundamentally believe it's because of the procreative capacity of that relationship. That is the only relationship out of which a child can come into the world. And we want to ensure that that child is in the right environment. And as the UN's Charter on the Right of the Child recognises that it should always be the case that the priority is that that child is brought up with its parents. That's what marriage does. It keeps the parents together for the sake of the child.
Okay, John?
Thank you. Mr. Dean, on the question of procreative capacity, would you say then marriage isn't appropriate for people who we would know in advance couldn't conceive children?
No, I wouldn't. I think marriage, saying that marriage is the environment in which procreation takes place, isn't the same as saying that we only have marriage for that reason. I think recognising typically, traditionally, throughout society, we've recognised three ends of marriage. We've recognised that you know, it is built on love. The couple definitely love each other, but for mutual comfort of the couple themselves, so they are attracted to each other. They have the capacity to have children, and the common good of society is aided by having that stable foundation for family life. That's the three ends of marriage. Now, sometimes those three do not always attain. So in the case of, there are some people who just cannot have children, and we certainly put a lot of effort into society to try and help them. You know, we do have adoption services, and there's even quite an emphasis just now on fertility service. So we try to ensure that environment is adequately understood and protected, but we're not saying that anyone who can't have children isn't capable of entering that relationship. But that's the archetypal model of what a marriage is. It has always throughout history, regardless of the changes, that is the inherent essence that makes it marriage. The fact that there's a complementarity between a man and a woman. The proposals before this committee are that a man and a woman don't matter. It's just they're completely interchangeable. We don't think the reason supports that position.
if I noted you correctly, and I may not have, but forgive me if I have, I noted you saying the purpose of marriage was to create an environment to ensure children have parents. Yeah. And for you, parents is two people, one man, one woman. It couldn't be any other combination.
Well, biologically, we know that a parent is a mother and a father. Yes, that's what parents are. Yeah.
Okay, thanks very much.
Dr. Bellatagi.
Just to add what John has said, it's not just the children, procurement of children, it's also the growing up of the children in the family, and that's been explained, and also the wider relations of kinship within the families and extended families. If we lose this, we lose a lot of the cohesion of the society. We know that there are relations which is based on the family, and the children are the focus of these relations, but not only at the time when they are children, even when they grow up, there's still the relation between the children and their parents, their grandparents, and that's what holds the society together. And it's important to keep this. In our tradition also, there are things which are also mentioned in the bill. There are certain relations which are not allowed to marry because they are so close in kinship. And if we start changing the definition of marriage from what we know and what we know about who is coming from which line and who is not, then this will be confused and will not know exactly where we stop and where we start. It will be very difficult to find who is related to who in these terms. Having a kinship relationship doesn't stop at only the father and mother. It's really much wider than that, not only for the time, but also for the future of the family.
Thank you, Alex.
I wanted to return to and complete the line of question that I started with, which is about the protections that are offered to religious organisations. And you know, I've been a member of this Parliament for a while, and I participated in the vote on same-sex civil partnerships some years ago, where I voted against it. And I get the impression that what we're dealing with here is a progressive move, rather than, you know, we have been progressing towards where we are. Now, the previous panel expressed their views and suggested that this was the end of the process, that this was perhaps the line in the sand. Do you believe that to be the case, or do you believe that where we are today with this legislation is simply a continuing step in a progressive process that may result in further changes to your protections or your rights as religious organisations in future?
Kieran?
Yep, I'll come in on that one. I think the first thing that we would say is that we welcome the fact there's an opt-in system. You know, we welcome that, and we welcome that the Scottish Government has recognised that churches should be free to marry according to their conscience and according to their belief. So we think that's a good thing. We know that that's not an opinion shared by everyone, and in fact there would definitely be some folk in Scotland that would say churches should be forced to do this. So we do welcome the fact the Scottish Government is taking a sensible approach on that. I think in answer to your question, our concerns are firstly on the robustness of that protection, the long-term robustness, and I suppose, you know, how long will that hold out for? You know, will it be the case that at some point a court case will come to try and force a church to marry a couple that they don't feel that they can marry? You know, I think we've started to see moves towards that in England already, and our concern would be that will come in Scotland, and it could go all the way to the European Court, where it may be that protection is struck down. At the moment, our understanding is that it's still considered within the margin of appreciation for states. So it may not be that happens now, but we would be concerned about that at some point in the future. I think our other concerns would actually be in the future much more wider than the actual celebrant aspect of the ceremony and of the marriage ceremony, and it would be about churches and organisations who who would still hold to a traditional view of marriage, and individuals who would still hold to a traditional view of marriage, will their views be accepted moving forward in wider society? Again, we appreciate that it's not the government's intention at the moment to say that this is an unacceptable view to hold, but is that going to come down the line, and will that have other wider effects on churches and on individuals?
Bring Marco in and then Reverend Easton.
Yes, I was just trying to pin down there. Your concern is not this bill in itself creating difficulties. It is subsequent court interpretation. So, for example, if Parliament was ever to require everybody to offer same-sex marriages, that would require another bill. You're clear on that with regard to legislation. What you're concerned about is court interpretation. Yeah.
Yeah, I mean, we do have concerns about this bill, which I'm sure we'll go on and touch on in some of the wider areas. And one of our primary concerns is that the only factor that the Scottish Government seem to see as a need for protection is the ceremony aspect of this and the celebrant aspect. So when we ask questions about protections for the bill, we're often met with, well, no celebrant will have to do this. I think, as I say, we accept that at the moment the Parliament is not proposing that. So our concern is absolutely on court interpretation, but also on perhaps in the direction of travel that at some point would become coercive.
Why you're so concerned about the Article 9 protections in the European Convention on Human Rights, which allow the freedom to practice your religion and indeed the legal opinions that are in the public domain. For example, Karen Monaghan, QC from Matrix Chambers in London, that said any attempt at European Court to force a religion to hold these ceremonies would inevitably fail because of Article 9.
Yeah, I mean, I think there are conflicting legal views. There are conflicting legal views on this, and I think that's where some of the concern comes from. We've not been there, we've not had the cases yet that have got there. Our concern is that the cases will come, and that we're in danger. We know that in a number of other areas, there have been concerns about the Article 9 protections and how far they go, particularly in areas where protected characteristics conflict. And so our concern would be that this would almost potentially opens a door to other situations coming. We don't want to be alarmist about it. We don't want to be jumping up and down about it, but there is a real concern there that our members have brought to me, certainly time and time again, that this could happen.
Easton, or Reverend Easton, I apologise.
Well, Reverend and Dr. Rice. I'm not sure how closely we are expected to respond to the questions. This is the sort of thing that could flow over into quite a general conversation, but I will try and direct my answer at the moment to parts of your question, Mr. Johnson. You've asked at the beginning why, bearing in mind there are opt-outs for this and conscience clauses and so on, we feel, I don't think you quite use this word, we feel threatened by this. I'm not sure that the Methodist Church does feel threatened by this. My brief statement that you have in front of you, hopefully, or have read at some stage or other, states our position, and that is the position of the Methodist Church. Whether we feel threatened by any legislation that may come through this Parliament or indeed through the Westminster Parliament as it has is another matter. The second part of your question was whether we see this as the end of a process or it might continue further. Whether you were thinking the continuing further was something that churches and other faith groups might feel would undermine their position further, I'm not quite sure from your question. Who can tell? Well, we've had marriage only between people of the opposite sex. Over the centuries, there's been a change in understanding, hasn't there? It's not that long ago, historically, when women were considered to be the possession of their husbands, and their property certainly was. But we no longer hold to that now. So one must assume that over the periods of time, presumably civil and even religious understandings of marriage may change. And I guess there's some sort of recognition of that on behalf of the Methodist Church when you'll see on the statement that our annual conference, which is the supreme governing body of the Methodist Church, equivalent, I suppose, to the General Assembly of the Church of Scotland, that we agreed to set up a working group that would revisit Methodism's understanding of the nature of marriage. I can't obviously predict what recommendations they will bring to the conference or how conference would vote on that matter, but that's where we are.
Mr. Deegan.
Just a couple of points to Mr. Biaggi's point on the protections. I think the trouble with if you want to use the ECHR to protect you is it costs you a lot of money to do it. It costs you a few £100,000 to go to that level. The Faculty of Advocates made an interesting submission to the government's consultation, and they pointed out, without taking a position on the principle, that the difficulty which will lead to which will definitely lead to a conflict is the Equality Act's section 149, which gives it the public sector equality duty. So what we will have is, so this